Buckle up. Today's hearings are all about probable cause. That's the legal threshold where the judge decides. Is there enough evidence to move forward, or does the case get shut down right here? Think of it as the courtroom's filter, and Judge Fleischer runs it with his own unique style.
So we are going to take it to the grand jury.
Okay.
So he may win this battle today, but he ain't going to win the war, and he's going to stay in custody.
Hey there, welcome to the Courtroom Files. So today I've got 3 separate probable cause hearings in Judge Fleischer's court, and we continue to bring you these probable causes because we find it interesting how Judge Fleischer works through the process in his mind. It's always different, every case. Sometimes he finds probable cause, sometimes he doesn't, but we continue to argue that he puts more effort into this than most other judges do, and we also contend that he's on a little bit of a journey regarding probable cause. You can just kind of see the wheels turning in his brain, and he's trying to really evolve his thinking. At least that's our opinion on it. So we bring you 3 more today. Take a look at them and let us know what you think. In the third one, as you saw in the little clip at the beginning, the prosecution actually gets a little bit aggressive with him. So be on the lookout for that whole thing as well. Also, if you look in the pinned comment, we'll put a link to a poll that we put in the community tab of our channel where we ask what you think a judge should do if he consistently finds that there is no probable cause in cases and it comes down to like bad police reporting. Take a look at that poll when you're done and feel free to participate in it because we'd like everybody's thoughts. Please do put a like on the video if you enjoy it. Subscribe to the channel if you have not already. We'd appreciate that. And let's roll the game film.
All right. Good morning, Mr. Lockridge.
Hey.
So you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On November 20th, 2024, the officer was dispatched to a group home in Harris County, Texas. Upon arrival, the officer spoke with the complainant, who advised that after her and the defendant, another resident of the home, got into a verbal argument, the defendant told him, "I'm going to fuck you up." The complainant stated the defendant then went outside, grabbed a bed frame, and stated he would tear this place up. The complainant advised he was not in fear, but advised he would like to pursue charges because he perceived the statement as a threat.
Here's a legal twist. The complainant admits he wasn't actually in fear. That's huge. For a charge like terroristic threat, fear is the engine that makes the case run. No fear. The law says no probable cause. Watch how fast the judge drops this one.
He's not in fear.
Yes.
You know? All right. I'm going to find no probable cause on your case, Mr. Lockridge, but be careful.
Yes.
You know, when you get upset and you say things that you really don't mean, they can get you in a lot of trouble, right? Have patience. It's not hard. And if you get upset, walk away. Find another release. But sticks and stones may bring you back to us, and you don't want to come back here, all right? Okay, man, just take a seat for me, okay?
We'll
Please.
dismiss it, Judge.
Please. Mr. McAlpin, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On November 24th, 2024, the officer was dispatched to a residence in Harris County, Texas, in reference to an indecent exposure call. And upon arrival, the officer met with the complainant, who stated that he observed the defendant inside his property without pants and underwear on. The complainant stated that he observed the defendant dry hump the air and roll around on the dirt. The complainant also advised he observed the front driver's side door of his motor vehicle to be open and observed his credit card missing and his in-car charger to be damaged. The defendant was the only person inside of the property at the time of discovery.
Trespass of what?
Okay, pause. Did you catch that confusion? Even the judge is asking. Trespass of what exactly? House, car, property? This shows how sloppy reporting can sink a case. And in probable cause hearings, vagueness equals freedom for the defendant.
Yeah, it's like, Your Honor.
Is it house? Is it car? Did I miss something?
Your Honor, just pled as being on the property. It doesn't specify if it was a vehicle, so. The complaint just stated that the defendant was inside his property area.
Was there prior notice of him not to be there? Or, because I didn't hear you say anything about prior notice. I didn't hear anything about you saying.
Your Honor, it was just the residence, and in the case of a residence, notice is presumed, and he was.
No. We don't presume anything in the law, you know? I mean, we don't go based on hunches and read it to me again, please.
Yes, Your Honor. On November 24th, 2024, officer was dispatched to a residence in Harris County, Texas, in response to indecent exposure. The complainant stated he observed the defendant inside of his property without pants and underwear on. The complainant stated he observed the defendant dry up the air and roll around in the dirt. The complainant also advised he observed the front driver's side doors of the motor vehicle to be opened and observed the credit card missing and in-car charges to be damaged. The defendant was the only person inside of the property at the time of discovery.
Yeah, I mean, there's no prior notice that he's not supposed to be there. You didn't say anything. You didn't say anything about he's
There's
trying
no
to.
statement as to without permission. The only thing is it is a residential area, Your Honor.
All right, I'm not going to find probable cause to go forward, Mr. McAlpin, but you're on notice now. If you go back to this place, they're going to probably arrest you. Do not go back to this place. Watch out what you're doing. You're on felony deferred for a very serious crime that can give you 10 years in prison.
This is where Judge Fleischer shines. He doesn't just toss the case, he uses it as a teaching moment. He reminds the defendant, you're already on felony probation. One wrong move could mean 10 years. It's not just dismissal, it's a warning shot.
You understand?
Yes, sir.
Behave yourself in the free world. And if you cannot, you're going to end up possibly 10 years. You understand?
Yes, sir, Your Honor.
Take a seat.
Thank you.
Alan, come on up.
I am approaching on behalf of Ricky Mason for probable cause.
Okay. Chief back there.
Oh, he's in the back.
On October 19th, 2024, officer was dispatched to a residential home regarding a call for service. Upon arrival, officer made contact with the complainant, who advised the defendant moved out of her house or near that one. The complainant advised that on October 19th, defendant arrived at the location and was hammering on the west side wall of her home. After the defendant left, the complainant discovered her porch light was not coming on. An electrician came by on October 19th to check the light, to which he advised someone had cut off her electrical wires, which ran around the exterior of her home.
Didn't we did this already though? Did we not?
Your Honor, can we have the full, instead of having
You want me to read the full day?
the full,
I'll read the,
Did we-
Judge, if you want me to read the full day, I'll read it.
because a key thing is missing there. When she asked him what are you doing, he said he's cleaning up. And she said, okay, and brought him food.
Remember,
Judge,
this is
that's-
just a probable cause hearing. When we get into facts, that's
Understand, Your Honor, but he never identified him as that's the individual that saw.
Judge,
okay. Well, hold on.
complainant is mentally immobile. She's on oxygen. When she asked whoever was there to announce themselves, the defendant announced himself. She never got up to see him. She is on an oxygen tank. She's largely mobile. I spoke to her.
All right. So first, he's charged with criminal mischief,
Yes.
right? The alleged mischief is what?
Cutting the electrical wires around her home. I can continue reading probable cause, Judge.
I guess go through the whole rigmarole. It's
You know, just keep reading
Yeah.
what I was reading. Okay. So electrician, okay. So an electrician came by on October 19th to check the light, to which he advised someone to cut off her electrical wires, which ran around the exterior of her home. The electrician advised the total cost of the wire and labor to replace the damage done to the light would cost approximately $535. The complainant advised the porch light was working on the night of October 17th and said defendant was the last person at the location and the last person to leave, and was the only person close to the missing wires and hammering on the wall where the wires were observed to be missing. Upon speaking to the complainant, she told me 3 years ago, he did the same thing to other parts of her home where he cut off the electrical wires there.
remember, right?
No, I'm just tying in.
I understand. So
Now the stakes rise. Cutting someone's electrical wires isn't just vandalism, it's criminal mischief. But proving intent? That's the real battle. The defense is pushing. Unless you saw him do it, everything else is just suspicion. And suspicion doesn't win in court.
criminal mischief is a specific intent crime, right? We got to know that he specifically intended to mischief.
Tendency to it. He's done this before in the home. He knows how to do it. He's done it before. He was there.
So he's working on this specific day.
He wasn't working there. He used to live with her. The complainant allowed him to live with her because she felt bad for him.
Okay.
Then she kicked him out. He came back after she kicked him out. She heard hammering on the wall, asked who was there because she can't really move. She's on an oxygen tank. The defendant announced himself, said it was him, and then said he was just cleaning up.
And what did she do next?
And the next thing we know is he
And the next thing you know,
leaves.
her lights aren't working. Her porch light's not turning on. An electrician comes by and he says that all the electrical wires have been removed around the house. And he had done this before 2 to 3 years ago in other parts of her home.
Your Honor?
I know. Hold on, Alan. I mean, I know where you're going.
He also
And I
just got
know-
released from jail.
Right.
Judge identified himself. He was there. She is very certain it was her upon speaking with her. And based upon just things he's done before in her home, he knows how to do it. He's done it before. He's removed electrical wires from her home before. Literally no lights in her home work anymore because of allegedly what he did, Judge. And I sympathize with her.
And I do as well. And it sucks. But I still have to follow along, right? We've got A, I've got C, but I don't have B. And while it doesn't make me happy, you know,
Just Your Honor, he was heard, and prior to announcing himself, he was heard hammering on the wall where the wires were missing. And then he was the only person known there to be at the location.
I understand. I get it.
I see him do it. Identify him as clean. Did not see him do it. She brought him food after. Time went by.
I'm gonna cut to the chase and just say, this case is gonna go to the grand jury, and we're probably gonna seek an indictment, so.
Then
it's not
you're not going to hurt my feelings.
know,
Like, I get
I'm
it.
just saying, we got somebody on oxygen during winter who has no heat.
Do a bench
because of
trial.
Somebody, and it wasn't her. Okay, it wasn't her who ripped out her wires. Okay, and if that was anybody's grandmother in here.
And
we are
here's
gonna
the
take it to
gut
grand
punch
jury.
moment.
Okay.
So he
The
may
judge
win
admits,
this
if this were your
battle today, but he
grandma,
ain't gonna win the
we'd
war
all
if
be
he's staying in custody.
outraged. But the law doesn't run on
So,
feelings.
I
It
know,
runs on
and I
proof.
feel it.
So the case
and I'm
stalls
sorry,
here,
but I
don't
have to
think
find
it's
no
over.
probable cause.
This
You
one's
know?
heading straight
Now,
for the grand jury.
tell him.
I don't think the argument would be made. So, we are gonna take it to the grand jury.
Okay.
So he may win this battle today, but he ain't gonna win the war, and he's gonna stay in custody.
So I know and I feel it, and I'm sorry, but I have to find no probable cause, you know? Now, tell him they're probably going to take it to a grand jury. Grand jury may indict it. I don't know what's going to happen, but, you know.
Thank you.